Advisor, former Commissioner for Body Corporate Community Management. With me, Frank Higginson, partner at Hynes Legal. Frank, welcome.
Hello, everyone, again.
Now, you may notice that this week, Frank and I are in different locations to our normal surrounds. That's because Frank and I, along with every other person and their dog, is currently down at the SCA, Strata Community Association State Conference on the coast. It's been a huge event, hasn't it, Frank?
Has been 300 plus people. I suppose lots of strata managers that might otherwise be watching this webinar will be downstairs at the moment having afternoon tea or whatever it might be. So yeah, we both adjourned. So here we are. So we don't actually look like gamers this week, Chris, with our little headsets. So hopefully the audio is okay for everyone through the laptops.
Yeah, no, it is. We've tested it thoroughly. But I guess this week's topic, Frank, is a nice segue from the conference, because there's been a lot of discussion at the conference about the new heightened feeling that people have in bodies corporate, being at home more, taking more interest in their investment, more interest in their body corporate. This then throws a new light and a new focus on committees, body corporate committees. And today we're going to talk about the restrictions, or the restrictions that should be on body corporate committees. I guess the first thing to say, though, and if you see me looking the other way, it's because I'm looking at a few notes over here. First thing to say, Frank, is that decision-making in a body corporate is by a group. But I guess the thing here is that you can't expect all owners to make decisions on absolutely everything, can you?
No, and that's what the committee's there for. I think probably the best analogy for me is always looking at it like a company. So if we say rather than have a body corporate, we've got BHP, the big Australian. We have a whole bunch of people that are shareholders that are akin to the lot owners in a body corporate, and there's a board of directors who make a bunch of decisions about the day-to-day management of the affairs of the company. And those are the people that really, again, day-to-day are saying, do this, do that, hiring, firing, all those sort of things. And they report to the shareholders every year. Certain things are reserved for consideration at general meeting of those shareholders, bonuses to directors and all that sort of stuff. But other than that, the directors are really let to run the show. And that's probably the best analogy I use for people in strata, except obviously on a lot smaller scale.
That's right. Yeah, that's exactly right, Frank. And it's ludicrous. I've actually had people say to me, we should be involved in, we as in voters, owners, should be involved in all decisions. It's ludicrous to suggest that. It's so time consuming, and it's so time consuming, and it costs a lot of money. Now, I have been told that perhaps there's a few audio issues at my end. Frank, keep talking, and I'm just going to see.
Have a play. So I suppose where the government's got to with this, and they have created the same sort of framework that happens with companies, in the sense that the statutory position, interestingly enough, is that a decision of the body corporate, a decision of the committee is a decision of the body corporate, unless it's a decision on a restricted issue or some other decision that the Act restricts for decisions of owners at general meeting. So in a sense, committee can do everything other than these things, and there's certain carve-outs that come with that. So, and my response, I suppose, always, and I've had a few conversations with clients, particularly in the last week, who are committees who are feeling under pressure for whatever reason, is if other owners aren't satisfied with what's going on, then they're well and truly entitled to put their hands up to go on committee to start to participate in that decision-making process.
Now, just for everyone's benefit, I can't get that headset to work, so apologies in advance for any rough audio. Frank and I can hear each other quite well. Maybe I'll just get a bit closer to the speaker. How about that? Yeah, I suppose the important. Keep going, Frank.
Oh, mate, so I was just going to start probably rolling into what the actual decisions are that I suppose we get questions on all the time. And the very first one, obviously, is spending.
Yep.
So, it's sort of where there's certain decisions. So a simple decision like the engagement of a lawyer is normally an easy thing to do, but there's a range of limits around committees in terms of what they can and can't authorise. So in the feed there's a link to a newsletter, which we'll put up, that we wrote about spending limits in bodies corporate, because there's spending limits imposed at both general meeting, which require 2 quotes, and also at committee level. So and probably the simplest way to start with that is that a body corporate in general meeting has the ability to change a committee spending limit. So the default position is that the committee can spend $200 by the number of lots in the scheme, plus, and that's it. So if you've got a 100-lot scheme, the committee spending limit might be 20 grand. But general meeting can change that. So what we have quite often, particularly with, I suppose, more involved projects, is that, say, we're going to redo the Port Cochere. So there's demolition, repaving, painting, construction, scaffolding, all that sort of stuff. That sort of expenditure is always going to be normally above what the committee can spend. But what the body corporate in general meeting can do is allow the committee to spend up to, say, pluck a figure, 100 grand for that particular project. And what that then means is that the committee's got control over what goes on. They can go up and down with the spending, they can negotiate the quotes, they can enter into the agreements and all those sort of things. And provided they stay below that limit, they've then got control of the process. So in a sense, Chris, I suppose that's where owners delegate, which is a naughty word in strata land, but they give the ability of the committee to run that particular project without the need to refer back to the owners for all of the individual bits and pieces for decision making.
And of course, there are oversights and all of that sort of stuff. So the most obvious oversight is when it is for owners to be kept apprised of what's going on via minutes and through other factors as well. There are some circumstances where a committee can spend above their limit. So as Frank has already authorised by GM, it's authorised at a general meeting by ordinary resolution, or if all owners have given consent to it. So that's obviously going to be much more likely in a much smaller scheme. Or if it's because an adjudicator has given them authority to do so, and an obvious example of that is an emergency expenditure order. If it's needed to comply with statutory notice given, say, through a court order or an adjudicator's order. So those are the circumstances where the committee can spend above the limit. The other new circumstance where a committee can spend above their limit is for insurance. So in the laws that kick off from Monday, a committee can spend above its spending limit for the purposes of either renewing or taking out an insurance policy. Important to note that the requirement for 2 quotes still exists. If it's above the relevant limit for major spending, that's assuming that 2 quotes can be found.
And the other thing I think that sometimes people forget a lot too is that we might have a body corporate budget. So we've got a budget which we need to have for the course of the year. So in the, like a figure, we've got $1 million worth of expenditure in there. That might include 100 grand for this particular project that we're talking about doing. Just because that money's in the budget, that doesn't mean it's an authority to spend it. So while it might be raised from owners in anticipation of it being needed to do certain things, the body corporate committee or the body corporate in general meeting still needs to make the appropriate decision to spend that and deal with quotes and deal with all of those limits and that sort of thing. It's a common misconception, that one. It's there, therefore I can do it. Not quite. You've still got to jump through the hoops to get the approval to actually spend it.
That's a really good point, Frank. Thank you for reminding everyone of that one. When it comes to improvements to common property, the committee can approve that up to the basic improvement limits, which is $300 multiplied by the number of lots in the scheme. But that's also subject to whatever their spending limit might be. So we come back to the first point, which is about there is a committee spending limit, which may or may not have been changed by ordinary resolution. And that's one of the oversights that owners have. If an owner says, I'm not happy about the committee spending, well, you have the oversight to either vote yes or no to any of those changes at a general meeting by ordinary resolution. For an improvement by a lot owner, the committee also has some restrictions on it there. So the committee can approve if the total cost is less than $3,000 and the improvement does not detract from the appearance of the lot and satisfied that the use of enjoyment does not constitute a breach. So, for example, a breach of bylaws or a nuisance. So again, the committee does not have unfettered power to approve a lot owner's improvement. Do that, Frank?
No, and so to me, the example I always use for that one is, say, you're in a standard format plan lot. The backyard is an exclusive use area, which is still common property, which means it's still in the domain of the body corporate, subject to what the exclusive use bylaw says. And the owner wants to put in a spa. So that might involve some foundation work, some concrete and whatever it might be as a pad to put the actual spa on. So that's the sort of thing you look at your spending limits there about whether the committee can approve that. So is it going to cause a nuisance? I suppose it depends how late you use it and all that sort of stuff. But that's the example of that I use all the time for that particular committee approval.
And if all of those factors cannot be satisfied, the improvement will have to go to a general meeting for approval by ordinary resolution. So there's another check and balance on the committee.
Yep.
And then probably the category that I suppose we're going to spend the most time on is what is called restricted issues. And that's, as the name suggests, these are issues on which the committee is restricted from making a decision. So there are two ways in which something becomes a restricted issue. Either the legislation says it's a restricted issue, or the body corporate has previously resolved that that's a restricted issue. So let's investigate that a little further. Let's unpack it, to use that parlance. So section 42 of the standard module provides for restricted issues for committees. And they traverse a few issues, don't they, Frank? It's fair to say that a restricted issue, if you want to think of it very, very generally, a restricted issue for a committee is anything which impinges upon somebody's rights, effectively, isn't it?
Yeah, in certain respects, you know what I mean? And this is the thing, like, it's sort of every body corporate decision, everyone's got an interest in, you know? So, and there's absolutely some grey, and the very last one of these, I think, is the example we'll talk about where the grey really comes out. But it's sort of, this is, and we don't tend to have too many fights over some of these definitions. So, I mean, the first one is that a committee can't fix or change contributions. They can't actually change levies. Now, I suppose, Chris, there's a slight exception to that for the COVID regulations that were out, which allowed committees to effectively change sinking funds and those sort of things. But absent those regulations, the budgets and the levies are set by owners in general meeting, and the committee cannot change them. So if there's a levy for 100 grand, the committee can't suddenly decide to make it 80 or 120. End of story. That's general meeting, and that's a restricted issue.
Really good point, Frank. So, and I suppose, again, if you're looking for rationale for that, levies and contribution, absolutely fundamental issue for a body corporate. So you don't want a small subset of the body corporate making a decision upon that. It's got to be open to all to vote on that. The next one, it's quite open to interpretation, changing the rights, privileges, or obligations of owners. On the surface of it, you think, oh, that makes a lot of sense. But one area where this came to light during COVID, and technically it was still in COVID, was about access to common property. So there were situations in which I know of at least one adjudicator's order where the committee shut down access to a particular area of common property and said they were doing it for COVID-related purposes. The adjudicator found that was a restricted issue because they were changing rights and privileges of that scheme. Government has subsequently made a legislative amendment to correct that particular scenario in that COVID situation. But generally, Frank, that's where it goes, doesn't it?
It does. And so the magic words there, I mean, rights, privileges, or obligations, I suppose it's imposing an obligation, it's affecting someone's right or privilege, which I suppose is accessing common property and those sorts of things in that circumstance, which was that adjudication. But it's of owners. It's not necessarily of the body corporate. So it's sort of, when you really get into having arguments about whether things are restricted issues and you're looking at this particular point, it's really, really important to characterise what is actually changing and whether that actually affects owners. I mean, that sounds rather obvious, but we get asked this one a fair bit, and you look at something the committee might be making a decision on. So, you know, shutting off access to the pool, in a sense, is a relatively black and white one in my book. You know, I'm paying my levies. I'm entitled to access the pool. There's no government regulation that says I can't access the pool. I want to access it. So that in that sense is definitely, to me, a restricted issue. So it's a bit of a no-brainer, I think, that one. But there's a whole bunch of other ones that lurk out from time to time that aren't necessarily that cut and dried. So I think that's usually one that you might need to get some legal advice on if you really want to push the point. Is probably what I'm saying, is because there's a lot of grey in that.
I think so. That's really open to interpretation. Yep. The next category of restricted issue is any decision that must be made by ordinary, special resolution, or resolution without dissent. That's pretty straightforward. So if the legislation says that a particular kind of decision must be made by one of those resolution types, it's a restricted issue. And the committee can't decide to override that. So, restriction.
Bylaws. And bylaws are probably best example there, aren't they? You know, I mean, bylaws. To change bylaws requires a special resolution, so the committee can't do it. And I suppose, Chris, we haven't really done a whole lot of bylaw stuff on these. Maybe it's definitely going to be a topic for the future. But where house rules are not bylaws. I'll just throw that in there as a little teaser. So a bylaw that says the committee can make house rules, which means they can change the hours of the pool and stop people using barbecues and things like that, aren't actually enforceable. So that's...
Yep. Yeah, and that's right. But importantly, committees can enforce bylaws.
Correct. Enforceable bylaws.
The next one. Anything, as we said this before, anything that a general meeting has resolved to be a restricted issue. And so what that means is that from time to time, it might be quite reasonable and quite valid for a body corporate to say that the committee can't decide on a particular issue. Fair enough. But I know, Frank, you and I have seen it. I used to see it a lot in the Commissioner's office where that kind of thinking wasn't so much about being reasonable, but it was a tactic. And it was a tactic to make approval of something more difficult. And the classic example of that is pet approval, isn't it?
Yeah, absolutely. So, you know, the proper pet bylaw would say is that before you keep a pet in your lot of your common property, you need the approval of the committee. One particular building we've run into twice decided that they didn't want pets, and therefore to make it more difficult for people to get pet approvals, they decided to make a decision of the committee on a pet approval a restricted issue, which meant that it had to go to general meeting to get approved, which is one more way to hamstring someone actually requesting that particular approval. So, yeah, we've overcome that a couple of times so far because there's still no way around it. But there's other things that it comes up from time to time too. Like you go back, there's one particular body corporate manager who's no longer in the industry, sold his practice and all that sort of thing, which is fine. But for whatever reason, he would always make the consideration of a management rights assignment a restricted issue at the first EGM of the body corporate when the developer was in control. So normally, a committee can consent to the assignment of the management rights agreements, and that's probably the best place for it in my book anyway, in terms of going through the process, meeting the proposed manager and all those sorts of things. But what that would mean is that you'd have to go to general meeting to get the approval of something that the body corporate can't unreasonably withhold consent to. So that would usually cause an enormous amount of pain in terms of educating owners around the sense of you can't say no unless there's a really good reason to say no. So to me, that, I don't know what the rationale was for doing that, but that makes a lot more sense for me to be kept at committee level, because that's where the relationship really should be.
Yeah, and so I suppose that's a trap for bodies corporate. Body care has to be taken in using it as a tactic, I would suggest.
Yep.
The final examples of what a restricted issue is legal proceedings, with some couple of very obvious exceptions. So most legal proceedings, I think, Frank, will require special resolution to commence.
Yeah.
Legal proceedings for debt collection and commencing an application in the Commissioner's office.
Yeah, so yeah, committees can commence Commissioner's applications, away you go. Committees can commence proceedings to recover body corporate debts. Now, it's really important to note body corporate debts don't include every single thing that might be on the owner's ledger. That's a really important distinction, because some things appear there that shouldn't be there, like, for example, electricity. So that's another webinar we should be doing. Electricity should be a private arrangement between the user of the service and the electricity provider, not the body corporate. Because if it's coming through the levies, it'll be based on the entitlement. So, and any proceeding other than that needs a special resolution. So a special resolution is effectively 2/3 of those who voted in favour. There's another two limbs to it as well, but if you get across that first line, you're usually there. So if you want to go and sue a developer for building defects, you want to sue an adjoining neighbour for interference with your property, you want to sue someone under a BMS, all of those things require special resolutions. You want to commence a planning appeal against an adjoining development. That's a special resolution in general meeting, because quite obviously, and I suppose, Chris, this is one of those checks and balances, the commencement of a proceeding is obviously a relatively substantial step to take in the life of a body corporate and exposes them to potentially who knows how much legal fees. And I suppose, as always, usually costs follow the event. So if you lose the proceeding, the legal fees are the other side. So that's a real big step off point, commencing a proceeding other than Commissioner's office or a simple debt recovery one.
And it's also consequence-based, isn't it? I mean, there are consequences from a legal proceeding. Whether you win or you lose, something happens out of it. So effectively what the legislation is saying is that in those situations where there are significant consequences from the proceeding, it's imperative that there be a very high threshold of approval. If the threshold is reached, well and good. Away you go to the legal proceeding.
And mate, what I might throw in is a couple of little horror stories there. I've seen this happen a couple of times where there's nothing wrong in a sense with drafting a proceeding, like drafting a statement of claim, but the commencement of it is actually filing it in court and serving it on someone. So I've seen it a couple of times where somehow something's slipped between the cracks, everyone's been wound up, proceeding's been filed, served, and then the defendant has turned around and said to the body corporate, I don't think you've quite got your special resolution there, guys. Can you please go and get that? And the committee's gone to try to do it and been defeated in general meeting. So what that means is that the body corporate's actually commenced an incompetent proceeding. And what that also means is that the body corporate is well and truly going to go under the bus on costs. So that's really, so if you're on a committee, that is a real, you want to, before you press any of those buttons, 100% be sure that you have that resolution across the line.
Yeah, definitely. I guess then if you're an owner or indeed you're on a committee or even a body corporate manager, anybody who has any dealing with the committee, there might be some quite good traction in saying, oh, let's make everything a restricted issue in that case. That's our ultimate form of control of things. But I don't necessarily think that that's the case. I mean, there's a reason why committees are empowered to decide upon the things that they decide upon, and that's so the day-to-day business of the body corporate can keep going. Basically, if you were then to start making things less about the committee deciding and more about a restricted issue, that's going to soak up so much time and so much money as well. It becomes an administrative burden to endure in that case. So I think you've just got to take a little bit of care with that. If you're out there watching and thinking, that's the easy solution to my issues with the committee, just think twice about that one, because it's not necessarily the case that that's going to be achieved that way.
Yeah, completely agree. You know, and it's become unwieldy, really, because it'd take a month almost to get every decision. So 21 days notice for general meetings, allowance potentially for quorums not to be there and all that sort of stuff. You really can't guarantee an outcome. Well, I suppose 30 days after you send the agenda, you probably can guarantee an outcome one way or the other, but that's a long time to actually allow a decision to be made as opposed to pressing a button to do something. And again, that's not to, I suppose, disenfranchise people or groups of owners who aren't necessarily happy with the way their body corporate's been directed. That's what the protection's there for.
Absolutely. And there is a scenario in which a committee is entitled to make a decision on something and then they actually effectively make it a restricted issue by not deciding upon it. And I guess the example here would be if the committee is entitled to make a decision, but there are some particularly serious implications or serious consequences of that, the committee might actually decide that that should go to the general meeting. But again, care needs to be taken with that. Again, it wouldn't necessarily be reasonable for that to be used as a delaying tactic.
No, but I've certainly used it once or twice acting for bodies corporates who are making, where committees are being asked to make decisions on issues that they know are going to be contentious, and they'd rather say to everyone, this is one for the building as a whole, not just for us. And that's fine.
Yeah, that might actually be some really good decision making on the part of the committee in that case. You just got to on the case-by-case basis. So, all of the above, those are all the restrictions on the committee. So you've absorbed all of that, and you're still thinking that there are some issues with your committee. Again, you might be on the committee, you might be an owner, you might be a caretaker, you might be a manager, you might be an occupier for that. When you think that the committee is acting outside of those restrictions, it's overstepping the mark on those restrictions. So the very first thing, you actually engage with the committee to the extent that you're able. It might be genuine error. That happens a lot, doesn't it, Frank?
Absolutely. And honest mistakes are honest mistakes. And that's the, you know, I suppose the joy and the pain of this whole strata regime is there are a bunch of rules. And I mean, we've sat there and run through the legislative regime for committee decision making today, and there is a lot of moving parts. And Chris, I think one that we did leave off the list that's really interesting is from a standard module perspective is the notice of opposition. So even if you're looking at differences between the modules, under the standard module, in theory, well, not in theory, what the law requires is that a committee can't give effect to a decision until 7 days after notice of that decision has been sent to all owners. because what that is designed to do is allow 50% of owners. If more than 50% of owners object to that decision, the committee can't do it. So in effect, there's sort of a restricted issue tail. I've used that once in 20 years.
Right.
Acting for a group of owners who are upset with what the committee was doing, believe it or not. So, but there's a whole lot of people in standard modules that would absolutely send those decisions out. So I suppose there's one more little nuance to those rules. So back to where you were starting there, Chris, is what do you do when you think something's going wrong? Gently ask the question. And I think for me, it's probably framing the way you do that's really important. Hey, you're doing this wrong. Is not quite the way to do it. Is I'm not quite sure that this is within your spending limit. Is that okay? You know, and obviously it's always handy to know the answer to the question before you ask it. And that's where I suppose these things might help. Our newsletter might help. The Commissioner's office might help to give some grounding around what it is that your concerns are and whether they're based on reality or not.
That's right. That's absolutely right. Well said, Frank. So, okay, you've tried that. Then you might put it in writing. And you might actually ask for the correct decision to be made, or the correct decision to not be made. I guess the ultimate sort of end point to that process, though, is that there might be an of the decision challenged in the Commissioner's office on the basis that the committee were not entitled to make the decision, or that it was unreasonable for them to make the decision, which...
Yep. And I suppose that's at that stage, if you've reached out to the committee, you've tried self-resolution, because that's obviously the first precursor before you can go to the Commissioner's office, is you've got to try to sort it out yourself. And Chris, this is another little segue into the new regulations that started on Monday of this week. Owners now have the ability to put motions to the committee on which the committee must make a decision. So this might be one of those ones, is that framing a motion in the right way to the committee to change the decision that's previously been made might be a genuine way to approach this problem that wasn't available as at Friday of last week.
I think absolutely. So I was talking to someone just yesterday who is going to do precisely that. They have a problem that previously they weren't entirely sure about how they could resolve. Now they've got this right to request something of the committee. They're going to utilise that as a precursor to going to the Commissioner's office. That's going to be their attempt at self-resolution. And I'd go a step further and say that the Commissioner's office will mandate that kind of thing.
Yeah. Okay.
So I would suggest that will actually be the outcome. I guess if things are systemic, like there are recurring systemic issues about the committee overstepping its restrictions, you need to look at what can be done to support and assist the committee. I mean, in the first step, it's some training. Commissioner's office, my former office, has a fantastic free online training module for committee members. Just because you're not a committee member, still do it, because it's great information and it really helps. We might also be thinking about something along those lines in the not too distant future. Please stay tuned to Hynes Legal about what that is all about. But look, ultimately, the end consequence to a committee not acting within its appropriate decision-making limits, replace one or more of the committee members, I suppose, particularly if there's one member of the committee who you can see is perhaps the, what would you call it, Frank, the instigator, the catalyst for that kind of decision making. But as always, be careful what you wish for in these kinds of circumstances. You need to have somebody to replace them, and you also need to be reasonably confident the person replacing isn't any worse. That absolutely happens. And I guess the ultimate end game to all of that, when you've got, we've talked about this in the previous webinar, haven't we, Frank? You've got a committee that is either rogue or dysfunctional, and that means things are not getting done at the scheme. There might have to be an administrator appointed at that point. Yeah,
and I mean that webinar we did on dysfunctional bodies corporate, we've got some more info to come on that, I suppose, too, Chris. Disagreement doesn't mean dysfunction. From an administrator's side of things, it's obviously a very serious step to have an adjudicator appoint an administrator, and that really needs to be one where the committee is absolutely blatantly breaching its statutory obligations and they know it. That's probably the safest way to put it, isn't it? If that's the case and they refuse to change, then that's potentially the direction you head. But there's obviously a whole lot of steps you've got to get through there to point that out to them, which is really what we've sort of walked through today to a degree in terms of that layering.
Absolutely. And one thing we haven't touched on, I mean, we've talked a lot about people who think that their committee is not making the decisions they're meant to. We've just put that link up to the article that Frank was talking about, so you can have a look at that. If people, if we've framed this in terms of owners, but for committee members out there who are watching this and you're not 100% sure that your committee is doing what it needs to be doing, or is doing too much, as in overstepping its boundaries, it's time to take some action about that sort of thing, because genuine mistakes can be forgiven, but systemic overstepping mark cannot be. And that's where you need to take some responsibility for your role as a committee member, take some responsibility for your decision making. There is the potential for some liability if you're not making those decisions in good faith, Frank.
Yeah.
So get yourself equipped, get yourself informed, make sure, and particularly when it comes to really big issues about lots of money and property management and complex technical matters, don't just go off half-cocked to make decisions on that basis. That you wouldn't do that in your own life. Why would you do it here? I just don't see why.
Yeah. Well, I think it's probably, that's a really good, I think, lots of money, changing the rules on people. If you had those as the two fundamental things you would say as a committee member you want to be wary of, that's what it would be. Be careful around those things, because they're the things that matter to people. And they're the ones you're potentially going to come unstuck. And that's certainly what the legislation's trying to provide some oversight with respect to those two particular issues.
Definitely. We've come to the end. Gosh, time flies, as always. Thanks, everyone, for tuning in. We've had really good engagement again. Next week, Frank won't be here. It's a very, very sad occasion. Not for Frank, sad occasion for everybody watching. Don't worry, you'll still have me. I know some people won't be thrilled about that either, but hey, you get what you're given. But look, don't forget to register for these, because once you register for these, that's where you get some follow-up material from us. If you don't register, we can't send them out. Please make sure that you do that. Otherwise, Frank, thank you.
Thank you. I think other than some maybe audio issues, which I haven't noticed, it seemed to go okay, but we'd love everyone's feedback on that, as much as we'll be back to usual next week.
Absolutely. Thanks, everyone. We'll see you next week.
Bye, everyone.